individual capacity in this matter. If possible, I'd like to reserve 5 minutes for rebuttal, please.
All right. Let's show 5 minutes in for rebuttal.
Okay. Your Honor, this appeal deals with the distribution of the assets of Gary Blankenship Sr., who died in August 2023. At the time of his death, Mr. Blankenship Sr. and the appellee, his wife, Shirley Blankenship, were involved in ongoing divorce proceedings in the Gibson County Chancery Court. My client, Gary Blankenship Jr., is the Blankenship son and the sole beneficiary of his father's will. The specific issue in this appeal is the proper classification of approximately $1.4 million on deposit with the Gibson County Clerk's Office. These funds represent the proceeds from the sale of several pieces of real property, which undisputedly the Blankenships held during their marriage as tenants by the entirety.
So we have no issue on that, is that correct, as far as the ownership of the land itself? I know we've got issues about the proceeds, but the ownership of the land.
That is correct. There's no issue that when the Blankenships were, when the property was real, so to speak, that they held it as tenants by the entirety.
Thank you.
Okay. Importantly, during the divorce proceedings, the Blankenships agreed to sell the properties, and this agreement was memorialized in a January 2023 order that was filed in the divorce proceedings. Under the terms of that order, the proceeds were to be deposited with the clerk's office. Neither side would have access to the funds, and the funds would be ultimately distributed when the divorce proceedings were concluded. In the trial court's April 17, 2024 order on distribution of the funds, the trial court determined that these funds should be classified as tenants by the entirety property. As such, the appellee, Mrs. Blankenship, was entitled to the full amount of the funds. The funds passed outside of the estate and went to her directly, and so Mr. Gary Blankenship Jr. didn't receive anything under from these funds. In essence, the trial court determined that the original tenancy by the entirety classification would extend to these proceeds. The trial court's ruling, however, failed to take into consideration the parties' intentions and whether they intended for the tenancy by the entirety status to attach to the resulting proceeds. Tennessee case law, specifically the cases of Oliphant versus McManus, which is a 1954 Supreme Court decision, and 2023 decision of this court in Boren versus Hill-Boren et al., indicate that the party's intent is an important consideration in determining whether or not property should be classified as tenancy by the entirety. In fact, if I may quote directly from the Oliphant versus McManus decision, whether an estate by the entireties has been created, quote, is a question of intent, quote, that may be inferred from the circumstances.
So let me ask you this then. What in the record specifically do you rely upon to say that the parties intended that these funds not be held as tenants by the entireties?
There's nothing that in the record that would indicate, I guess, nothing that I'm aware of that say that they did not intend it to have it intended. However, I think that the circumstances of the situation here, as noted in this decision, may be inferred from the circumstances. What we have here is two individuals going through a contentious divorce, and in the divorce filings themselves, they have included statements of animosity between them. You have a situation where there is the love, honor, and affection between the spouses is not there. Based upon the Oliphant decision, where we can infer from the circumstances, that's what I would assert.
So basically you're relying upon a somewhat subjective standard, aren't you, there to say that the love and affection was no longer there? I mean, obviously these parties were getting a divorce. That's one factor here. But everyone who files for divorce doesn't ultimately end up getting divorced.
That's correct. It is a subjective standard, and it's based upon the facts and circumstances of the particular case. For example, if the Blankenships had reconciled, that would have been a factor in determining whether or not they intended to maintain the tenancy by the entirety. In this case, they didn't do that. But again, the case law is very clear on this point, that it says the intent may be inferred from the circumstances. In looking at the cases, the Oliphant decision and the Hill cases, the courts looked to a somewhat subjective standard and looked at the totality of the circumstances and the facts and circumstances surrounding the case and the particular facts.
But I don't think either one of those cases were used to, or had circumstances where property that was titled as tenants by the entirety then was no longer tenants by the entirety. Weren't both of those cases where property that was not titled jointly ended up being determined to be marital?
That is correct, Your Honor, but there's nothing in those cases that limits that. The cases don't have any limitation on the creation of the tenancy by the entirety or the termination. Again, the issue in both those cases was the intent of the parties. What is it that the parties intended? And based upon the totality of the circumstances.
So, but applying those cases to the facts of this case would be extending that line of reasoning then to somewhere that it has not yet been taken. Would that be a fair assessment?
That would be a fair assessment, Your Honor.
Okay.
Thank you. I also note that when Your Honor asked a few minutes ago about what is on the record that would also indicate the animosity, one thing that should be noted is the agreement to sell itself, because under the terms of that agreement to sell, the parties were prohibited from accessing the funds, and the funds were to be distributed pursuant to the divorce decree. Had Mr. Blankenship lived, the funds would not have been paid out solely to her. They would have been paid out to each individually.
Are you referring to the January 5, 2023 agreed order?
Correct, Your Honor.
And in looking at that, I think perhaps you're inferring a little bit there. That's a very short order.
It is short order, Your Honor.
Then it's ordered that, number one, all proceeds of the sale of any marital property in this cause shall be paid to the registry of the clerk and master. Number two, that all other and further issues are reserved. That's pretty much all it ordered, wasn't it?
Well, correct. That's all it ordered, but it's done in contemplation of the divorce. I mean,
But you said that, well, go ahead. I'm sorry. Just
No,
go ahead.
Your Honor, no, please. Again, it's done in contemplation of a divorce. There's no reason that you would enter this particular order where the funds could not be accessed unless it's in contemplation of the ultimate distribution of the divorce.
And the deposit of the funds into the clerk's office, that was in both parties' name. Is that correct?
I believe that it was.
There was no division, one half for the deceit and then one half for the spouse?
I believe that's correct. I'm not 100% sure about that, but I believe that when the funds were deposited with the clerk, it was done on a trust for both of them, but it was not listed as a tenancy by the entirety.
Or as tenants in common, all right?
Correct, Your Honor. The trial court, in making its ruling, based it primarily upon the cases of Burt versus Edmonds and White v. Watson. And as noted in my brief, it's our position that those cases are distinguishable because in those cases, it was undisputed that the parties intended to maintain the tenancy by the entirety. It benefited them for a number of reasons. We don't have that situation here. In this particular situation, we have it where there's a question of intent. And so for that reason, I believe those cases are distinguishable. Finally, again, going back to the Oliphant and the Hill decision, it's the appellant's position that the trial court was required to take proof regarding the parties' intentions and make a factual determination as to their intentions regarding these proceeds. Since that was not done, the appellants would respectfully request that the April order be overruled and the matter remanded back to the trial court for further proceedings. Thank you.
All right, you have your rebuttal time.
Good afternoon. My name is Nicholas Latimer, and I represent Shirley Blankenship in this case. By looking at the agreed order from January 5th, 2023, we can glean from that order, this was a written agreement between both spouses. This was a written agreement to sell tenants by the entirety property. This was a written agreement to deposit the proceeds from the sale of tenants by the entirety property in an account that only the spouses could access. Importantly, the agreed order states that the property subject to the order is marital property subject to the jurisdiction of the divorce court. The law is clear, straightforward, and easy to apply, and comports with this state's long-standing concepts of protecting marital property rights, both in the creation and the dissolution of such rights. The Tennessee Supreme Court in Burt v. Edmonds and this court in White v. Watson hold clearly that there is a presumption that the proceeds from the sale of property held by tenants by the entirety remain tenants by the entirety unless there's an express agreement to the contrary by both spouses. Burt and White have been the law for nearly 50 years and squarely apply to this case, and there's no reason to overturn or modify the long-standing precedent. In the case at bar, the trial court applied Burt and White to decide correctly that Shirley Blankenship is entitled to retain the proceeds from the sale of the tenants by the entirety property as her sole property. The appellant's arguments to the contrary are simply without factual or legal support. First, the appellants argue that the conveyance of the property itself terminated the tenants by the entirety. However, this argument flies in the face of the clear authority of Burt and White, and this argument, especially in light of the agreed order in this case, would turn that presumption on its head. Since there's a presumption, it's the appellant's burden to prove an agreement to the contrary. Further, the appellant argues that agreeing to deposit the proceeds in the clerk and master's trust account somehow destroys the unities of title and possession for tenants by the entirety. However, this argument mischaracterizes the facts. The clerk and master did not obtain ownership of the funds, but merely held the funds the same way that a bank would in a bank account. Whether the funds were deposited with the clerk and master into a bank account, neither spouse would have unfettered access because of the automatic divorce injunctions in the case. As admitted in the appellant's brief, the purpose of depositing the funds in the clerk and master so that neither spouse could have access to those funds. But if the spouses had agreed that the funds were supposed to be held as tenants by the entirety or a separate property, there would have been no need for the agreed order. If it were intended that the proceeds be tenants in common or separate property, the spouses could have simply sold the property, divided up the proceeds as they agreed without the intervention of the divorce court. We think it's clear from the agreed order that the funds were to be held as marital property and divided by the divorce court. The appellant cites Appellant for the proposition of the party's intent should be inferred from the circumstances. However, Appellant is distinguishable in this case because that case dealt with the creation of tenants by the entirety when there wasn't a clear documentary evidence of whether I think it was personal property or bank accounts, whether that personal property was tenants by the entirety or not. But the White case is controlling on this point because it held that the tenants by the entirety can be terminated only when there's an express agreement between the spouses, when one spouse dies, or in the event of divorce.
Mr. Latimer, let me ask you this. Your opposing counsel says not only should intent matter, but that the trial court here was required to take proof on the intentions of these parties, what the intentions were when this property was sold, and what is your answer to that? Was the trial court required to take any proof on that?
I don't think they were. We had a presumption here, so I think based on what was in front of the trial court, they could apply that presumption, and the argument would be that they have to rebut that presumption, and the appellant in this case is responsible for rebutting that presumption by offering proof. In this case, the April 2nd, 2024 hearing, both Ms. Blankenship and Mr. Blankenship, Gary Blankenship Jr., they were both at that hearing. They did not offer any type of proof. They didn't offer for Mr. Blankenship to testify, anything of that nature.
So you're saying that no one even attempted to call a witness that day?
They did not. No, there were no witnesses attempted, no offer of proof other than arguments of counsel. And then when we had the motion to alter and amend, I don't think Mr. Blankenship was there that day, and no proof offered. There were no affidavits from, Mr. Blankenship or any interested witnesses that they offered saying, hey, look, we've got this evidence that we want to enter. They just had a blank statement in their motion that says, hey, we want to enter some, we want to put on some proof, but they never tried to put on proof in this case.
So at the trial court then, when the issue was presented to the trial court, what evidence did the trial court consider? Since there was no testimonial proof, what evidence did the court consider? Was there documentary proof or what?
The parties basically stipulated to the facts that the parties were married, they own the properties by tenants by the entirety. There is the agreed order to sell the property, and that Mr. Blankenship had since died. I think those were pretty much the...
And I've looked at your briefs, obviously I've read your briefs, but correct me if I'm wrong, I don't think there is a transcript or a statement of the evidence in this case, is that correct?
I don't think, we agreed with the statement of the facts of the appellant's brief.
All right.
I think Oliphant and White can be read together, but not allowing Oliphant to wipe out or modify White, because the Oliphant, well, going back to the policy of the White case where it requires an express agreement between the spouses to terminate or sever the tenants by the entirety. I think that's a good policy, good rule, because it protects marital property rights, as does Oliphant. I think it's a good rule. It's a better policy to be more inclusive into what is tenants by the entirety property, but to be less exclusive as to what is not or is no longer tenants by the entirety. If you read Oliphant and White together, they support this policy to protect marital rights, because Oliphant is more inclusive as to what can be or what is marital rights or marital property. But the White case, it has a more bright line rule about what is not or what does not convert from tenants by the entirety property to tenants in common. Appellant argues that the tenants by the entirety property is no longer tenants by the entirety property when the trust, love, and affection between the spouses is gone. I think this position is likely kind of dangerous precedent and could open the floodgates to litigation. Appellant's brief says that they're not seeking a bright line rule on the issue, but where do you stop the line? Is tenants by the entirety converted when the divorce is filed, before divorce is filed? Does the trial court have to make factual findings of when that loving feeling was lost? Does such a finding remove that property from jurisdiction of the divorce court? What happens when the main asset of the divorce, as usual, is the marital home? Can a creditor or an heir come back and sue the other spouse saying, hey, y'all didn't love each other long before the divorce. That property is no longer tenants by the entirety. It was tenants in common. The Tennessee law is clear and establishes a presumption that proceeds from the sale of entirety property remains that status unless both spouses agree otherwise. No such contrary agreement was made in this case. In fact, we think the agreed order clearly evidences an agreement that the proceeds were to remain tenants by the entirety property. Trial court properly applied Tennessee law, and the appellant has failed to demonstrate any basis for reversal. This court should affirm the decision of the trial court. Thank you.
Just very few. follow-up points to some of the statements. First of all, one thing that I'd like to point out is in the Oliphant decision that was actually cited by the Hill case, it gives some guidance to, I guess, what the courts should be looking to determine the standard for overturning the presumption, as Mr. Latimer was talking about. And I'd read from the Hill decision, which incites the Oliphant case, and it says, rather, the Oliphant court held that whether property titled in one spouse's name is nevertheless owned by both spouses and tenants by the entirety, quote, should rest upon convincing evidence, end quote, and not upon, quote, mere conjecture of the party's intent, end quote.
Let me ask you a question about evidence, since you bring that up. Mr. Latimer stated to the court that this was presented to the trial court upon a stipulation of fact. Is that correct?
So, Your Honor, to be frank with you, Your Honor, I was not involved in this case prior to at the time of the April 2nd hearing, so I cannot speak to what was done. Mr. Blankenship Jr. had a different counsel at that time.
Well, I understand that, but there's no one here to answer that question
Sure.
on behalf of your client except you.
I would say that yes, I think that the facts were stipulated at that hearing.
Mr. Latimer also stated that no one attempted to call a witness that day, that I think, first of all, there was no testimonial evidence. Do you agree that there was no testimonial evidence?
I do agree with that, Your Honor.
And no attempts at testimonial evidence that day?
That's correct, Your Honor.
And I had also asked Mr. Latimer, we have no transcript here.
That is correct as well.
And no statement of the evidence?
There was, I guess when I filed the statement of evidence, it did not include a transcript or there was no documents that were presented into evidence. Nothing was marked and exhibited at any time.
Okay, all right. Thank you.
Thank you. But very quickly to that point, I would note that, again, as part of the motion to alter or amend, we specifically did request the ability to conduct some discovery in this matter and or to present the proof. And at the trial court hearing, the trial court determined that proof was not necessary based upon the trial court's reading of White versus Watson and the Burt versus Edmonds case. Finally, Mr. Latimer stated that there is a requirement for an express agreement there's necessary for an express agreement in order to create a tenancy by the entirety. And respectfully, based upon the Oliphant decision and the Hill decision and several other decisions of this court, which have been cited in our brief, I don't believe that is the case. I think that again, the creation of it can be inferred from the circumstances, and there's no requirement that there be an express agreement on that point. Your Honors, I appreciate your time this afternoon.
Thank you. All right. Angie, you can call the next case.
Ray Braxton M.